Hello, Business Law. Hello, Business Law 2 students. This is your final lecture, all right? And today we will deal with the title and risk of loss issue that are located in that chapter, all right? And if you'll recall, title simply reflects ownership. So it's anything that basically reflects ownership. And in business, right, for example, in a sales transaction, the seller transfers title to the buyer, right? But as with any transaction, an entrepreneur would certainly be able to understand this. There may be and there may arise a risk of loss. So here we'll be talking about transfers of ownership and who bears the risk. For example, let's say it's perishable goods, right? Let's say it's any product that's perishable, right? Anything could happen. Goods can be damaged en route to the buyer once the buyer purchases them, right? Who bears the risk of loss? The goods could be damaged at the source, right? They could be damaged once they've reached the point of delivery. The UCC helps us to understand who is it that should bear the risk of loss in those cases. Before the creation of the Uniform Commercial Code, the sales laws were focused on title, which was ownership. And the sales laws, and the UCC still addresses title, which is the actual indicia of ownership, with regard to sales of goods. Obviously not with regard to leases, because actual title doesn't transfer. At least in most leases, generally title doesn't transfer at all. Some categories of leases, title can transfer, but we're not so much worried about that. But many of the concepts that were dealt with under the old rules, under sales law, are now dealt with regard to title, are now dealt with regard to risk of loss under the Uniform Commercial Code. So we will get a little deeper into risk of loss shortly. First, let's deal with title and the ways in which it is relevant under the Uniform Commercial Code. All right. So, in order for goods to transfer between a seller and a buyer, right, with which Article 2 is concerned, those goods have to be, quote, identified, end quote, right? So this process of identification simply means that the specific goods that the buyer intends to obtain and the seller intends to sell are specified, right? That's basically it. So, in the most basic iteration, I walk into the store, I pick up the goods, I take it to the counter, right? And I pay, right? That good has been identified as the one to which title is going to transfer, even if it's just a candy bar, right? And then my payment in exchange for being able to walk out of the store with my receipt and my goods, right? Those goods have basically been identified and title can transfer. So in a situation where we have a contract, but the goods have not yet been identified, we would not have title passing, even though the contract may be partially in the executory stage. Identification is also relevant to leases, however, as well as to sales of goods. But whereas in the context of a sales of goods, the identification permits title to pass, right? In the lease of goods, this permits a risk of loss to potentially pass between the parties. And that risk of loss is what permits a leaseholder to, for example, like lease a car. I can obtain insurance on it, right? If I didn't have the risk of loss, then I wouldn't be able to obtain insurance on that car, on that vehicle. And so the three things that we would need to be aware of, three categories of identification, if you will, are those for existing goods, those for future goods, and those for goods that are part of a larger group of goods, or goods that are part of a larger mass, right? So if the goods exist, the title can pass at the time and the place of the choosing of the parties, right? So I can, we can make the contract today and we can say title is going to pass in 2 weeks, or title is going to pass when you've delivered the goods to me, right? UCC 2-501, a similar concept appears in UCC 2A-217, not exactly parallel, but they're both in there under the same title, right? So Litco Company contracts to lease a fleet of 5 cars designated by their vehicle identification numbers. Because the cars are identified, right, and if it's not otherwise stated, identification has taken place. Litco acquires the insurable interest at that time, at the time of contracting, right? So that's one way that that could play out. Now, with regard to goods that are not yet in existence at the time of contracting, it's a slightly different approach. We call these future goods. Future goods are goods that aren't in existence at the time of contracting, right? So if the sale or lease involves unborn animals that will be born within 12 months after contracting, then the title to that unborn animal passes when the animal is conceived, right? So let's say we've got a stud racehorse, and I would like to pay you for your mare for your stud horse to breed my mare, right? Or no, wait a minute. Let's flip it around. I'd like to acquire a racing quality horse from you, right? Once that animal is conceived, right, and if it's the unborn animal that is the subject of the contract, then the ownership is acquired at the time that the animal is actually studded out, right? So if the sale involves crops that are going to be harvested within 12 months, or the next harvest season occurring after contracting, then as soon as the crops are planted, the title passes, right? Otherwise, the title can pass when the crops are begin to grow, right? For any other sale or lease of future goods, like manufactured goods, right? The title passes when the goods are shipped, marked, or otherwise designated by the seller as the goods to which the buyer's or lessor's contract relates. And accordingly, the rule for goods that are in a mass or goods that are part of a larger group of goods is similar to the last rule, right? So goods that are part of a larger mass are generally going to be identified at the time that those goods are set aside, shipped, or otherwise designated as relating to that particular customer. And this essentially involves separation or otherwise designating the goods. In the case where those goods are fungible, meaning that they're basically alike. One McDonald's hamburger patty is pretty much like all the others, right? So if the contract is about McDonald's style hamburger patties, one might say that those goods are fungible, right? If those goods are fungible, then the owners to those goods may hold those as tenants in common, then the seller can pass the title to the buyer without having to actually separate those goods. Once the goods are identified, then we have to deal with the issue of the passage of title. And so the UCC 2-401 or 2A-401 each apply to the passage of title upon identification, right? And throughout that passage, it uses the phrases, unless otherwise agreed, ... And that simply refers to the freedom of contract that the parties have in order to establish an alternative way of dealing with the issue. But that is, there's a default provision that the UCC provides. Think of it that way. So unless otherwise agreed, title passes at the time and place of seller's performance. The seller performs by delivering the goods, right? So if I'm going to an art auction, right, and I buy a painting from you, right? You're the seller, I'm the buyer, right? When you bring that painting to me, you have basically delivered. Whether I paid you or not, title will pass, right? Obviously, I'll be liable for the payment. I need to make the payment, right? But whether or not I've yet made that payment, will pass, which means that I now have the ability to insure that good that previously I wouldn't have been able to do. So, the type of contract will determine whether delivery has occurred, and obviously delivery again will determine whether title has passed and risk of loss may be assumed, right? So, in a shipment contract, we got shipment contracts, destination contracts, and then delivery without movement of the goods at all, right? In a shipment contract, the seller is required simply to put the goods into the hands of the carrier, whatever that is, like FedEx or the U.S. Postal Service. In a destination contract, the seller is required to have the goods delivered by a carrier or other to a particular place, like a warehouse or dock or something, right? And it's also possible for the goods to simply remain exactly where they are and for the seller and the buyer to pass title that way. That's basically delivery without the movement of the goods. And risk of loss in that situation will be determined by whether or not the seller is required to deliver to the buyer like a bill of lading or a warehouse receipt or some other indicia or title document, like in the transfer of a car, whether or not that the seller and buyer are required to produce that type of document in order for the risk of loss to pass, right? So Greg sells lumber to Bowden. They agree that Bowden will pick up the lumber at the lumber yard. So that is delivery without movement of the goods, right? If the lumber has been identified, right? So if he wants 10 bales of lumber, that's not the proper terminology, but let's just assume 10 bales of lumber, right? And there are 1,000 bales of lumber there, right? Once they identify those 10 bales, something happens, right? So if the lumber has been identified, segregated, marked, or in any way distinguished from the other bales of lumber, right, then title passes to Bowden when the contract is signed, whether or not Bowden is there to pick it up, all right? If the lumber is still in the large storage yard without having been separated, then title doesn't pass to him until the particular pieces of lumber to be sold to him under the contract are actually identified. So what happens if the person who is in the position of passing the title, the seller or lessor, right? What if their title is imperfect, right? And again, the reasons that title can be imperfect can be complex, right? Like the goods could be stolen or the goods could simply be clouded, right? So this is one type of problem. So UCC 2401, just as it deals with when the title actually passes, it also, in subsequent sections 402 and 403, deals with situations where the title is imperfect and a party attempts to sell or lease them, right? So a buyer can unknowingly purchase goods from a seller who isn't the owner of the goods, right? If the seller is a thief, right, the title is void. There is no title. It's just like a void contract. It doesn't come to exist, right? So if you steal the television and you sell it to me, I walk away thinking I own the television. I don't, right? What I have is a tort action against the person who sold me the stolen television, right? So Saki steals diamonds owned by Bruce. Saki has a void title to the diamonds. If Saki sells the diamonds to Shannon, Bruce can reclaim them from Shannon, even though Shannon acted in good faith and honestly was not aware that the goods were stolen, right? So it is fairly strict in that sense. All right. So what happens if, for example, goods are obtained by fraud, right? Paid for with a check that's later dishonored, right? Purchased on credit when a seller is insolvent, which is not permitted. Under the UCC, this results in what's known as a voidable title. A voidable title is different from a void title. I mean, you're familiar with the notion of a void contract not coming to exist, so it's not a contract, right? And a void title not coming to exist similarly. Voidable has a similar contract. A good faith seller with a voidable title may pass on the imperfect title that they possess. So this is a contrast to a void title in that a seller with voidable title can sell a good title, a re-perfected title, to a good faith purchaser for value. And a good faith purchaser for value is defined as one who basically purchases the good without a reason to know or knowledge of the circumstances that would make a person of ordinary prudence ask about the validity of the seller's title, right? So they have to be a good faith purchaser, so they have to have no knowledge of that circumstance, and they also have to purchase for value, so it can't simply be a gift. So we go back to legally sufficient consideration from Business Law 1, right? So, which basically means it's got to be a bargained for exchange. The real or original owner cannot recover goods from the good faith purchaser for value. However, they may be able to recover from the wrongdoer in the chain, right? And so that's the difference between a void title and a voidable title. UCC-2-403 contains the entrustment rule. When goods are entrusted or placed with a merchant of goods of the kind, then that merchant has the power to transfer title, even though they don't hold the title. Think in this case of a consignment shop. So entrusted goods include both goods that are turned over to the merchant and purchased goods that are left with the merchant for later delivery and pickup. So 2A has a similar rule for leased goods. So a person who is a buyer in the ordinary course of business is a buyer in the ordinary course of business, and they can receive title if they are buying the goods in good faith, right? The goods are purchased without knowledge that the sale violates the rights of another person, right? The goods are purchased in the ordinary course from the merchant, right? And the sale to that person is consistent with the usual and customary practices in that kind of business, right? Because in cases where goods are entrusted, why would we need to talk about buyer in the ordinary course of business? Because there can be sales of goods accidentally, right? The wrong goods might be sold to the end user or the buyer. And this determination of whether or not the goods are purchased in the ordinary course of business then becomes a determination of whether that buyer must return that good or whether there must be consequences for the sale of that good to the buyer, right? And so this entrustment rule basically allows innocent buyers, that's why they call them buyer in the ordinary course of the business, it's really an innocent buyer, to obtain a good title to goods which may have been imperfectly transferred, right? The merchant may not have been authorized to transfer the title, or the merchant simply may not have had title to the goods. So an example, Jan leaves her watch with the jeweler to be repaired. The jeweler sells both new and used watches. He accidentally sells Jan's watch to Kim, who is unaware that the jeweler had no right to sell it, although it was entrusted to him. Kim is a good faith buyer. Under our definition, she bought the goods in good faith. They were purchased without knowledge of Jan's having placed it simply for repair, right? The goods were purchased in the ordinary course from a jewelry merchant, where one might expect to find that type of good. And the sale to the person was consistent with the jeweler's customary practice of selling both new and used watches. Right. So Kim, as a good faith buyer, gets good title against Jan's claim of ownership. Kim only obtains those rights that are held by the person here entrusting the goods, right? So if Jan, who placed the goods with the jeweler for the repair, had a stolen watch, then Kim would not have had good title, right? Similarly, Jan, although she does not have an action against Kim, does have an action against the jeweler. See how this works? We're trying to basically split this up so that the potential liability falls on the party who is most responsible. So at the beginning of this lecture, I mentioned that title, right, and identification, right, passage of title, identification and passage of title were tied to the idea of risk of loss, right, and that title had to be passed in order for an insurable interest to exist, right, for certain goods which would be insured, right, and so one could get the impression that the passage of title and the assumption of risk of loss are the same thing, and they aren't necessarily. The UCC doesn't necessarily require that the risk of loss pass with title, right? The parties are free to come up with some other arrangement. The risk of loss is generally going to be determined by the contract between the parties. When that's not identified in a contract for the sale of goods, then the court has to basically go through other exercises in order to determine whether the risk of loss has passed. But the parties are free to devise any arrangement as between them that would parse out this risk that the goods will be damaged, lost, or otherwise not usable. So for those goods that are going to be shipped, right, we know that there are shipment contracts as well as destination contracts. And so we'll look at each of those in turn. So Pittman is a seller in Texas. He sells 500 cases of grapefruit to a buyer in New York. FOB, Houston, free on board, Houston. The contract authorizes shipment by carrier. It does not require that the seller tenders the grapefruit in New York. Risk passes to the buyer when conforming goods are properly placed in the possession of the carrier in Houston. If the goods are damaged in transit, the loss is the buyer's risk of loss. The buyers do have recourse against the carrier, but not against the seller, right? And that free on board or FOB language simply means that the seller basically places with the carrier, pays that expense, right, on its part, and then that risk basically transfers to the buyer. And that's UCC 2-319A and 2-5091A, and with regard to leases, UCC 2A-219. If, on the other hand, it's a destination contract, then just as it may intuitively seem, that risk of loss is going to pass to the buyer or the lessee, as the case may be, at the time that the goods are actually tendered to the buyer or lessee at whatever destination is specified. That's UCC 2-3191B, 2-5091B, and with regard to leases, UCC 2A-2192B, right? And there's an exhibit in your book around the same time that kind of defines some of these terms, including the term free on board, which specifies the free on board, FOB, which specifies free on board contracts, FAS, which specifies free alongside ship contracts, CIF and CNF and delivery ex ship contracts. Those are not, I'm not focusing on that, but they are terminology that kind of fits in with some of the provisions of the UCC, which may be applicable in your work. And so then we have the situation where the goods are going to be delivered to the buyer or lessor without actually being moved by the seller by the seller or lessor. The goods are going to be delivered without movement by the seller or lessor to the bailee, right? This is getting toward the end. This is delivery without movement by the seller or lessor to the buyer or lessee without movement, either at the seller's place where they hold the goods or through a third party. And a third party who holds goods without holding their title is called a bailee. And so the process of placing these goods is called a bailment. A bailment is a temporary delivery of personal property without the passage of title into the hands of a care person known as a bailee. Under the UCC, the bailee is the party who, by a bill of lading, or a warehouse receipt or some other sort of indicia or document of title, acknowledges possession of the goods, and contracts with the seller or lessor to deliver those goods. All right, and we'll come to that in a second. But first, we're going to deal with goods that are held by the seller. So, Henry Gano purchased a 12-foot beam at a lumberyard. The lumberyard loaded the beam onto Gano's truck but did not tie it down. It was policy not to secure loads for customers. After he drove onto the highway, the beam fell out of Gano's truck and he was injured while trying to retrieve it. Gano sued the lumberyard for negligence, but the court held that Gano, not the lumberyard, bore the risk of loss and injury after he left the lumberyard's presence. Once the truck was loaded, the risk of loss passed to Gano under the UCC because he had taken physical possession of the goods. This is in accordance with UCC 2-509 sub 3. If a seller is a merchant, risk of loss to goods held by the seller passes to the buyer when the buyer actually takes physical possession of the goods. Simple as that. If the seller is not a merchant, the risk of loss to goods held by the seller passes to the buyer on tender of delivery. This means that the seller bears the risk of loss until she makes the goods available to the buyer and notifies the buyer that such goods are available. In the situation where the goods are held by this third party we've just described as a bailee, there's a slightly different rule that obtains. So we know that a bailee, in order to be a bailee, must have a document reflecting the title that he does not hold, although he holds the goods that relate to that title, right? So he holds the title document, whether it's a bill of lading, warehouse receipt, some other type of title evincing document. And then under 3 circumstances, that title will then pass along with that, that risk of loss will then pass along with that title, right? So 1, the buyer receives a negotiable document of the title for the goods from the bailee. 2nd, the bailee acknowledges the buyer's right to possess the goods. Or 3rd, the buyer receives a non-negotiable document of title and the buyer has a reasonable time to present the document to the bailee and demand the goods. That's the case where they get the title document from the seller and then they take it to the bailee in order to pick the goods up. So we're getting close to the end here. There's just a couple more parts. We want to talk about breach, right? And then we want to talk briefly about insurable interest, right? So we go through this hypothetical. A buyer orders 10 stainless steel refrigerators from the seller, FOB, the seller's plant. The seller ships white refrigerators instead. The white refrigerators are non-conforming goods, which we've discussed. And they are damaged in transit. The risk of loss falls on the seller. Why? Those goods don't conform. They don't even have to be accepted, right? Had the seller shipped stainless steel refrigerators, instead, the risk would have fallen on the buyer because they were conforming goods that were shipped, and once they're shipped under that FOB designation, that risk passed to the buyer, right? But only because they were non-conforming goods did that risk of loss remain with the seller. In the case, let's take the case where we have the stainless steel, right? And there is the stainless steel was the order. The white refrigerators were shipped, non-conforming goods. Risk of loss remains with the seller, right? Unless one of the following occurs. 1, they have to cure the defects, right? The goods are repaired, replaced, and discounted, for example. Or the buyer accepts the goods in spite of their defects, right? Therefore, effectuating a waiver of their right to reject those goods, right? That's the case where the seller or lessor breaches. In the case where the buyer or the lessee breaches, the general rule is that when they breach, the risk immediately shifts to them. So this rule has 3 important limitations. First, the seller must have identified the contracted goods. The buyer bears the risk for only a commercially reasonable time after the seller or lessor has learned of the breach. And the buyer or lessor is liable only to the extent of deficiency in the seller's insurance coverage, because that would be, if they have insurance, then they've already basically received some recompense for that loss. And so here's a last word, a last segment really on insurance, right? You have to have some risk of loss in order to obtain insurance. You don't necessarily have to have title in order to have an insurable interest, however, right? So a buyer or a lessee has an insurable interest in the identified goods, because we know that once the goods are identified, they can be transferred, the title can be transferred, right? And so if the title can be transferred, then we have the risk of loss. And as a result, they have a right to be able to obtain insurance. So the moment that that contract identifies those goods, then the insurance can be obtained. UCC 2-501 sub 1 and UCC 2A-218 sub 1 basically accomplish the same thing with respect to sales and with respect to leases. When they don't specifically agree on identification in the contracting document itself, then the UCC provides that provisions on identification will, in other situations, right, it will look to what has happened between the parties, right, to determine whether the goods have been identified sufficiently for the risk of loss to transfer and for an insurable interest to arise. Now, a seller has an insurable interest in the goods prior to their identification and prior to the transfer of title, prior to the transfer of risk of loss, right? But the seller also has an insurable interest in the case where they retain a security interest. Why would they retain a security interest? Let's say that it's an installment sale, right? The seller still has a risk associated with that deal. So that security interest, which is the right to secure payment. We haven't talked about secured transactions in this course. There just isn't enough time. But it's the right to secure the payment to protect, right, those future payments by having a lien of sorts against the goods that are transferred, right? So I've got boats, right? I pay them off I normally pay them off with installment sales transactions, right? The seller has a right to have an insurable interest. So when I take my insurance out on a boat that I'm still doing an installment sale on, right? The seller can have a security interest in that boat, and they therefore also have an insurable interest in that boat. All right. So that brings us to the end of title and risk of loss. I want to say I'm very grateful for how active and diligent and attentive you guys have been this semester. I look forward to assisting you in your careers in any way that I personally can. As far as recommendations, you've all just been an amazingly wonderful class. I look forward to viewing your presentations, and I know that they'll be great. I will be responding to your questions this week. It's been a little tricky this week because I've been trying to deal with four and a half times as many Business Law 1 students. But I wanted to let you know that you are not forgotten. Please give me a call if you absolutely need me, but I'm working my way through my list of students who need my attention, and I look forward to a successful close of the semester. Thank you so much, and I will see you next time. Take care.